Everyone, please stand. Y'all may be seated. Livingston County Court at Law number 2 is back in session and calls number M329248. Let the record reflect that the defendant, Mr. Herbert Glenn Harrison, is present in the courtroom. Let the record also reflect that Mr. Harrison's attorney, Sir John West, is present. Let the record also reflect that the state is present with Assistant District Attorneys, Attorney Kobe Hallpower, and Attorney Lamar Johnson. Let the record also reflect that the jury panel is now present in the courtroom. Mr. Hallpower, is the state ready?
State's ready.
Mr. West, is the defense ready?
It's ready, yeah.
Okay. At this time, ladies and gentlemen, our court administrator, Ms. Brilla Jackson, is going to call some names. And now I'll put you in the hands of Ms. Brilla Jackson.
Good afternoon. When I call your name, please have a seat in the jury box. Mark Bush,
Mark Bush, jury box right here. You have a
Lauren Noack,
make sure you put your tags on.
Valerie Castle, Angela White, Cynthia Warburton, William Decker.
Okay, ladies and gentlemen, make sure that you button the tags onto your clothes. Now, at this time, ladies and gentlemen of the jury, earlier I had mentioned to you there was 2 administrative matters that I had to perform. First administrative matter was giving you the oath on the panel. Now I must give you the oath as jurors in this case. And so at this time, I need each and every one of you to raise your right hand. And once I finish administering the oath, please say, "I do." Do you and each of you do solemnly swear or affirm that in the case of the state of Texas versus Herbert Glenn Harrison, the defendant, you will a true verdict render according to the law and the evidence, so help you God? Okay. You may put your hand down. Members of the jury, I will give you some instructions and a general idea of what to expect in this case. Every case is composed of facts and the law as it applies to the particular case. The facts come from the witnesses on the witness stand. The law comes from the statutes, codes, rules, and court decisions, interpreting them and how they may apply to this case. You and I have equal authority in this case, but it is divided authority. You are the sole judges of the facts, and I am the sole judge of the law. You are the sole judges of the credibility of witnesses and the weight to be given to their testimony. You can believe all of what a witness says, part of what a witness says, or none of what a witness says. As the trial progresses, the attorneys will probably make objections to questions asked by the other attorney of witnesses, or objections to the introduction of documents or objects. This means that in the objecting attorney's opinion, there is a legal reason why the testimony or document or object should not be received by you. Sometimes I will simply sustain or overrule the objection. At other times, it may require a lengthy discussion outside of your presence. If that happens, I will either ask you to step outside for a few minutes or ask the attorneys to come up to the bench so that you can't hear the discussion on the point of law. The reason for this, as I told you earlier, you're the sole judges of the facts you receive, and I'm the sole judge of the law. I can't be with you in the jury room when you deliberate the facts. Therefore, you can't be present or within hearing when I deliberate questions of the law. The reason why I will sometimes ask you to step outside is because it is simply the most efficient way to do it. Otherwise, if we were to leave the courtroom, the court reporter would have to gather her equipment and take it with her, and the attorneys would have to gather their files, etc. The rulings I do make on questions of law in your presence are not evidence, and you are to disregard them. After all the evidence is in, and both the state and the defendant have rested their cases, the court will prepare and submit to you a written charge instructing you on the law in this case. We will then hear oral arguments from the attorneys. The attorneys have the right to make a summation of the evidence and to make reasonable deductions from the evidence. Since the state has the burden of proof, it has the right to open and close the summation or argument. Until you retire to deliberate, do not discuss this case amongst yourselves, and under no circumstances should you permit anyone to discuss the case with you. Do not attempt to learn from any source outside of the courtroom anything about the facts of the case, nor attempt any independent investigation on your own. Don't visit the scene involved in the facts of the case. Don't read any reports in the newspapers or watch TV reports about the case. Do not make up your mind about this case until all the evidence is in and you have been instructed on the law. Don't take notes during the progress of the trial. Don't visit other courts during a break if a trial or other proceeding is in progress. And please wear the pins on your clothes at all times while you are in the courthouse. Ladies and gentlemen, those of you who were not selected on this jury, on behalf of the citizens of Jefferson County and the staff here in County Court at Law Number 2, I would like to thank you for taking time out from your busy schedules to be here. Our judicial system could not move without people like you who take time out from your busy schedules. Because with our system, it takes citizens from our local area to sit and listen to evidence so that we can decide cases and so that justice can be done. So again, on behalf of the staff here in County Court at Law Number 2 and the citizens of Jefferson County, I'd like to thank you for taking time out from your busy schedules. I know that when you came here this afternoon for jury service, you probably looked over the door and you saw County Court at Law Number 2, Judge Terrence Holmes, and you probably said to yourself, this is Judge Holmes' court, I'm in the right place. Well, this is not Judge Holmes' court, this is your court. I'm only a citizen in Jefferson County serving the people. Anytime that you are in this area, that is, anytime you're in the courthouse, please feel free to come have a seat in your courtroom. The area that you're sitting in, we call that the peanut gallery. It does not mean that you can sit up in here and eat peanuts because this is not the Texas Roadhouse. However, you can come and have a seat in your courtroom and see what goes on in Jefferson County. And Our court reporter, not our court reporter, but our bailiff have some letters that he's going to give to you. Now, when you're in the area, we have some good coffee. So if you're a coffee drinker, we have some coffee. You can sit back and sit down and chat with us, and you can enjoy some coffee. Or if you have drink water or soda, we'll have that for you as well. So again, before I dismiss you, normally I give each and every one of you a handshake, but under these circumstances, I cannot give you a handshake. However, I can give you an air handshake. And so I give each and every one of you an air handshake. And thank you for coming here today. You're now in the hands of our bailiff, Mr. Charlie Porter. And everyone, please have a blessed day. Everyone. Okay. Now, ladies and gentlemen of the jury, the hour is late. We're going to start back on tomorrow. As I mentioned earlier, we have a docket in the morning. It starts at 9 o'clock. What that is, we have other cases that we'll be handling at that time. And if I'm not mistaken, we anticipate that we'll probably be working through lunch. And so we're going to need each and every one of you to come here, to be here for 1 o'clock. And at 1 o'clock, we'll start back with our case and make sure that you have your tags on, identifying you as a juror. And at this time, ladies and gentlemen, you are excused for the evening. Everyone, please stand while the jury exit the courtroom. And each and every one of you have a blessed day.
In here at work.
No, you're gonna wait outside in the hall, and the bailiff will come get you and bring you in. The court will be in recess, 1 o'clock on tomorrow. Okay.
Thank you.
You're welcome.